वेलकम बैक टू माय चैनल। सो गाइज, आज हम आपको देंगे 100 वर्ड्स पर मिनट की डिक्टेशन विद 800 वर्ड्स लीगल। सो स्टार्ट करते हैं बिना किसी टाइम वेस्ट किए। स्टार्ट। दिस अपील was made at the instance of the contesting respondent in both the civil appeals, who was really aggrieved of a clause in the prospectus issued by the appellants, which, according to her, was not valid. According to the contesting respondent, she, being a Canadian citizen, is an NRI, that therefore she was entitled to seek admission to the MBBS course in the NRI category quota, but yet the definition of NRI as specified in the prospectus issued by the Chandigarh administration and the Medical College Chandigarh for the academic year 2012-13 would denude her to of such status, and therefore it was liable to be struck down. The contesting respondent claimed that her grandfather retired as an under secretary in the year 1994, that when he was in the services of the state of Chandigarh, he resided in a government house from 1964 to 1983 and shifted to another government accommodation provided by the Chandigarh administration from 1983 to 1993. That third set of government accommodation was provided by the government to the father of the contesting respondent, which was occupied till December 2003, and that thereafter her father started living in the house of her grandfather in Mohali. The contesting respondent claimed that she passed as a regular student from Mohali, that the prescription contained in paragraph 2 of the prospectus providing for eligibility and merit for NRI seats for MBBS course, stipulating that the grandparents or parents of the candidates should be resident of Chandigarh for a minimum period of 5 years at any time since the origin of Chandigarh, and should have immovable property in her name in Chandigarh for the last at least 5 years, and a certificate to that effect issued by DC cum estate officer or Municipal Corporation of Chandigarh. It was on that footing that a challenge came to be made by the contesting respondent in the High Court in CWP number 1423 of 2011. The learned single judge by order held that the impugned clause was totally impracticable, illegal, illogical, and declared as such. However, the learned single judge went further into the question as to whether the contesting respondent can be granted admission. This special leave petition has been filed against the judgment and order dated 24th April 2008, passed in writ petition number 228 of 2006 by the High Court of Andhra Pradesh, by which the writ petition against the order of dismissal of the petitioner's application and successive appeals under the Right to Information Act 2005 has been dismissed. In the said petition, the Direction was sought to be by the petitioner to the respondent number 1 to provide information as asked by him vide his application dated 15th November 2004 from the respondent number 4 a judicial officer as for what reasons the respondent number 4 had decided his miscellaneous appeal dishonestly. The facts and circumstances giving rise to the case are that the petitioner claimed to be in exclusive possession of the land in respect of which civil suit number 810 of 2000 was filed before additional civil judge Ranga district playing for perpetual injunction by Dr. Rao against the petitioner and another from entertaining into the suit land. Application filed for interim relief in the said suit stood dismissed. Being aggrieved, the plaintiff therein preferred CMA number 180 of 2000 and the same was also dismissed. Two other suits were filed in respect of the same property, impleading the petitioner also as the defendant. In one of the suits, that is OS number 8753 of 2003, the trial court granted temporary injunction against the petitioner. Being aggrieved, petitioner preferred the CMA number 64 of 2003, which was dismissed by the appellant court, respondent number 4, wide order dated 10th August 2004. Petitioner filed an application dated 15th November 2004 under Section 6 of the RTI Act before the administrative officer cum assistant state public information officer respondent number 1 seeking information to the queries mentioned therein. The said application was rejected. Wide order dated 23rd November 2004 and an appeal against the said order was also dismissed. Wide order dated 20th January 2005. Second appeal against the said order was also dismissed by the Andhra Pradesh State Information Commission. Wide order. The petitioner challenged the said order before the High Court, seeking a direction to the respondent number 1 to furnish the required information immediately.